Welcome to The Explainer. Today we're diving right in and tearing down a massive, high-stakes illusion. We live in a world where digital evidence is basically the default witness in modern litigation. It's literally deciding people's freedom, their finances, their entire futures. But here is the terrifying truth. Digital evidence in modern courts is dangerously misunderstood. Understanding the actual mechanics behind the curtain is absolutely everything. So today, we're going to learn how to litigate digital evidence with discipline instead of just relying on instinct.
So if it's digital, is it accurate? This is a pretty provocative question, isn't it? We all have this natural built-in human bias to just trust whatever a machine spits out. But we need to sound a massive warning alarm here. We are treating easily manipulated, highly fragile digital files as infallible truth. We just assume that because a file was pulled from a computer or a smartphone, it must be an objective reality. But you know what? Digital data is fragile. It gets synced, cached, transcoded, and overwritten every single day, completely legally and totally normally.
Okay, let's dive into this. Our human intuition is to look at a screenshot of a text message and think, hey, I see it, therefore it's a flawless original. But the technical reality is entirely different. A screenshot is highly editable. It's really just a picture of a temporary display state on a screen. It usually strips away the invisible metadata, the actual real data, and strips away the context. It's an incredibly weak form of proof, yet somehow it's treated like gold in courtrooms every single day.
To truly wrap our heads around this, we're going to anchor this entire explainer on a brilliant core thesis from legal and forensic experts Mian, Zafar, Iqbal, Kalanauri, and Kaukab, Jamal, Zuberi. They state, digital evidence is never just a file. It is an assertion plus a process. The assertion is the human story you want to tell, like, he sent this threatening message. But the process? The process is how that data was actually created, stored, retrieved, preserved, and dragged into the courtroom. If you can't prove the process, your assertion is really just fiction.
This brings us to Section 1, the 3 core burdens. Let's break down the heavy lifting of admitting evidence.
You see, lawyers frequently fail in court because they argue admissibility as one messy, confusing blob. They scream, "It's not authenticated," when they actually mean, "My client didn't type that." To find the real truth, we have to separate this heavy lifting into 3 distinct chronological buckets. First up, integrity. Are we looking at the exact same bits of data that existed at the time of the event, or has it been altered? Second, identity. What is this exhibit really? Is it a native file, a provider record, or just a screenshot? And third, linkage. How does this file actually connect to the accused person? And here's the kicker, winning just one of these is not enough. You have to prove all 3 to genuinely validate digital evidence.
Now, what's really interesting about this slide is how we can demystify a piece of technical jargon you hear all the time, the hash. When we talk about that first burden, integrity, we often use hashes. Think of a hash as a unique digital fingerprint for a file. It verifies the bit-level identity of a copy. But listen closely here. A hash is just a copy verifier. It is absolutely not a lie detector. It proves the file hasn't changed since it was collected. It definitely does not prove the actual contents of the file are true.
Which leads us to a massive legal error, what we call the identity fallacy. Investigators love to argue, well, we seized the device, therefore we proved the story. No, you didn't. The reality is that a device is just a plastic and glass container. Just because someone owns a phone doesn't mean they authored every single message on it. Ownership is easy to prove. Authorship, now that is an entirely different beast.
This hits right at the heart of our third burden, linkage. If a crime happened via a text message sent at 9:17 p.m., the question isn't, whose phone is this? The real question is, who controlled the device at exactly 9:17 p.m.? Think about it. People share passcodes all the time. Kids use their parents' iPads. Accounts get hacked. Devices get stolen. Proving control at the exact moment of the event is the only way to establish true linkage. Without it, your evidence is completely disconnected from the actor.
This transitions us nicely to Section 2. Beware the context trap. Let's see what happens when preservation logic becomes presentation logic.
And this brilliantly illustrates a really fascinating psychological twist. Because our devices contain our whole lives, lawyers often try to dump everything into the courtroom under the guise of providing context. Often, a digital extraction contains maybe 10% of data that's actually relevant to the legal elements of the case. The other 90%? It's highly emotional, embarrassing, or shocking digital history that has absolutely nothing to do with the crime. A tiny slice of relevant data gets completely drowned out by massive amounts of unfairly prejudicial data. The jury stops asking, did they commit the crime, and starts thinking, wow, this is just a bad person.
Overcollection creates moral theater instead of legal truth. Just because a forensic investigator collected a massive 50-gigabyte folder full of crude texts or disturbing search histories doesn't mean a jury should ever actually see it. Case law logic, from landmark rulings like Old Chief or Curtin, tells us that judges must meaningfully weigh this. If the material provokes disgust totally out of proportion to its actual probative value, it needs to be excluded.
I really want you to internalize this powerful rule from the source material. Preservation is broad, presentation must be narrow. Yes, for sure, copy the whole hard drive so evidence isn't destroyed. That's preservation. But when you walk into a courtroom, courts must force advocates to narrow their digital exhibits down to the absolute minimum necessary slice that proves the actual legal element, nothing more.
Which brings us to Section 3, the Authentication Playbook, separating ownership from control. Let's move to and see how this builds practically in a live dispute. This playbook is the exact tactical blueprint experts use. Instead of arguing one messy admissibility issue, disciplined experts break authentication down into 4 distinct claims. Step 1, the device claim. Step 2, the account claim. Step 3, the user claim. And Step 4, the content claim. These must be argued and proven completely separately. Let's look at what each one actually demands. Step 1 is the device claim. The proponent has to prove this data came from this particular device. This is all about strict provenance and the physical chain of custody. You need the seizure documentation. You need the device's unique serial number. You have to ensure the physical hardware wasn't tampered with between the crime scene and the forensic lab. If you have unexplained gaps in who held the phone, this entire claim just crumbles.
Step 2 is the account claim. This data is associated with this specific service. Now, a massive mistake here is relying on display names. Display names and profile photos are incredibly weak identifiers. Anyone can change their display name to look like someone else, right? True authentication requires linking the digital artifact to a service-side identity, like a unique account ID, a subscriber record, or provider logs pulled directly from the tech company's own servers.
Step 3 is the user claim. Listen, this is the heavyweight champion of the playbook. This person controlled the device or account at the relevant time. I cannot stress this enough. This is where most criminal disputes happen. This is where that sloppy reasoning of, well, it's his phone, gets severely punished. You need real evidence like biometric unlocks, 2-factor authentication logs, or location data proving the accused was physically holding the device when the enter key was pressed. And finally, Step 4 is the content claim. This content is an accurate representation and not materially altered. Context matters so much here. If you selectively crop a screenshot to remove exculpatory context, or if you ignore the rest of a text thread that completely changes the meaning of a single sentence, that is a form of substantive distortion. You aren't just presenting an incomplete file at that point, you are literally presenting a lie. To help judges and lawyers evaluate these claims, our source outlines this brilliant testability hierarchy. Up at the top, Tier 1 is the gold standard, a forensic image with hashes. It's highly testable. Tier 2 is provider records. Tier 3 is user exports. Think of downloading your WhatsApp chat history. But look down at the bottom. Tier 4 is screenshots, and Tier 5 is basic printouts. Screenshots sit near the very bottom because they strip metadata, destroy the provenance chain, and completely block meaningful testing by the opposing side.
And this brings us to a really crucial legal distinction. Often, lawyers will scream best evidence to block a printout, arguing it isn't the original copy. But fighting over whether a file is technically a copy is usually the wrong battle in the digital age. Under modern rules, printouts actually can be accepted. The real fight is authenticity, proving the item isn't staged and proving the format hasn't stripped away metadata necessary for a fair trial. That is the battlefield that actually matters.
So the crucial point is perfectly captured in this brilliant high-stakes analogy from our authors. Digital evidence sits quietly in phones, then shows up in court wearing a suit it didn't tailor. By the time a digital file makes it to a jury, it's been extracted, filtered, parsed, printed, and handed a narrative by a lawyer. It looks authoritative, but it is your job to ask, who made that suit?
So what should you take away from this explainer? Well, it's essentially a rigorous checklist for survival in modern courts. Demand the provenance of every digital file. Relentlessly separate the 4 authentication claims: device, account, user, and content. Insist on the minimum necessary digital slice to avoid unfair prejudice. And above all, protect the process to protect the truth. Mastering these frameworks isn't just some technical exercise. It's literally the only way to prevent innocent people from going to jail based on digital illusions.
We leave you with this stark, memorable mic drop question to contemplate. Is your reality editable? Because right now, in systems across the globe, easily altered digital files are speaking way louder than human witnesses. The next time you see a screenshot presented as undeniable truth, ask yourself, how would you defend yourself against fabricated digital evidence? Stay curious, stay focused, and never stop questioning the process.